Well, let's do a deep dive into the concept of two parties in a contract situation at loggerheads over something fairly fundamental, signing up to an agreement to resolve those disputes amicably with experts rather than generalists. Well, the issue of who best decides, therefore not always an obvious default to their adversarial process of court proceedings. Indeed, the need to continue that agreement, to keep that business relationship alive, practically means it's in the interests of both those sides to opt for an alternate process, in this case arbitration, and that's where the Chartered Institute of Arbitrators comes to the fore. Remedies that have enforcement options globally, as well as training a cohort of expert decision makers on these disputes. In the case of the Australian chapter as well, working to see this country the go-to destination into the future for resolving disputes regionally. Well, the Chartered Institute of Arbitrators holding its annual get-together this weekend. Its president, Caroline Kenny QC, is live into the show alongside special guests from Paris, Alexis Mourre, president of the International Court of Arbitration in Paris. Warm welcome to you both. Here we are gathered together, and Caroline, perhaps I might start with you. If you could set the scene really on the chamber here, what's really on offer, and how are you looking to really cement a role of experts and training to give us really that cut above our weight presence?
Well, Carson, the Chartered Institute of Arbitrators Australia operates in all the states, and we provide networking opportunities for the arbitration community, but a large and important part of what we do is our training courses, which provide a pathway to fellowship or membership and equip the candidates with a globally recognised qualification and enables them, if they want to participate in an international career.
Now, you've yourself built on this, have you not, from being a barrister, as you continue to be? So this is very much an adjunct. It's not an either-or, but it's entirely logical to look inside that profession as an alternate route, as an alternate career, or a concurrent one even.
Yes, indeed. It's I do still operate as a barrister, but I must say that it's very nice to sit as an arbitrator and to be in the seat of the judge. So we offer through our courses the opportunities for people to actually train up as arbitrators. And what we're seeking to do in Australia is to build and educate a critical mass of lawyers that will be able to either participate in arbitrators as counsel or as arbitrators.
Alexis, come into the discussion and let's go bigger picture. Here you are, based in Paris, the seat of the International Court of Arbitration and the International Chamber of Commerce. We're talking about 100 members from about 90 countries. When you look out at the sector and you look at change as it inevitably always occurs, how are you doing this incrementally without triggering heavy-handed regulation, particularly on things like ethics in the profession?
Yeah, thank you. The ICC is, in fact, the main international arbitral institution. It has more than 180 members spanning 110 jurisdictions, and we administer cases from not only Paris but also from New York, from Hong Kong. Now we are starting a case management team in Sao Paulo, Brazil, and we will soon open one in Singapore. Arbitration is the normal way, the normal means of resolving international disputes, both in commercial arbitration and also as far as investor-state disputes are concerned, those disputes that oppose an investor and a state. And it is therefore highly important that trust is maintained in what is in fact a global system of justice. And in order for trust to be maintained, it is indispensable that all players in the arbitration, arbitrators, councils, abide by the highest level of ethics. And that is what an institution like the ICC looks after by implementing rules which are aimed at making sure that arbitrators and council abide by these rules of ethics.
You're pulling no punches, Alexis, on this trip and saying calls for another separate body to act as the kind of that watchdog on ethics. A council, a global arbitration council, are unwarranted. That frankly, when two sides to an agreement come together, they've already got the wherewithal to get this one over the line. Don't add to the complexity. Don't disrupt what's not broken.
I think one should distinguish the ethical question regarding arbitrators and regarding counsel. Arbitrators, essentially what is fundamental is that arbitrators are transparent in their disclosures of conflicts. And it is upon arbitral institutions to look after that. And the ICC has adopted rules which are very advanced, one of the most advanced in the world in this regard, to make sure and to request and direct prospective arbitrators to disclose to the parties any circumstance that is such as to putting their independence and impartiality into question in the eyes of the parties. This is fundamental because if this information is not put on the table, the parties are deprived of their right to object to the appointment of an arbitrator, and that might have tremendous consequences as far as the validity of the award is concerned. Another aspect of the ethical question is ethics regarding counsel. Ethics regarding counsel includes questions such as not misleading the tribunal, in particular as far as question of facts are concerned, and also cooperating in good faith to the conduct of the procedure by, for example, by not unnecessarily obstructing the arbitration.
To that point
and
on
these are
obstruction.
also questions on which...
Yeah, indeed. That was very comprehensive. Thank you. Just to build out on that idea of obstruction or otherwise, Caroline, often speed is of the essence in resolving these disputes. Just if you could compare, contrast what's often seen as a lengthy, drawn-out court process that one has to brace for versus this alternate track. What kind of a fast track are we typically talking here? How quickly can things get resolved?
Very quickly. You could obviously have very long, drawn-out arbitrations, but I've been involved in arbitrations that have been resolved in 3 months. It's party autonomy, so you're not sort of relying upon any outside body to impose time limits, and so the arbitral tribunal has the power to impose time limits, and it will generally work with the parties to come up with dates that suit them and that are convenient. But yeah, it can be resolved very quickly compared to court proceedings.
And if I may, and the ICC has adopted rules to ensure that arbitrations are conducted in a time and cost-efficient manner. In particular, for small claims, we have recently introduced expedited rules which make sure that the award is made in 6 months from the start of the arbitration.
Can we talk?
And of course, Carson, the beauty of...
Carry on.
Yeah, I was going to say and add to it that the beauty of arbitration is that once you have an arbitral award, it can be enforced in, I think it's 158 countries that are now signed up to the New York Convention. So enforcement can be a relatively quick process as well.
Just wondering as well how important it is, Alexis, to get the judiciary in any jurisdiction behind this scheme and how Australia looks compared with, say, Singapore in this region, Hong Kong. Putting to one side Europe for a moment, are we as vibrant, as supportive as we could be, or you'd argue there's perhaps more to be done?
Well, it is fundamental for any arbitration seat, and there is nowadays a competition between jurisdictions to attract as many arbitration as possible on their territory. It is fundamental in this regard. It is in fact probably the most important condition that the judiciary is supportive of arbitration, and that means that there is no undue interference in the arbitration, that there is a case law that is supportive to enforcement of awards, and that judges enforce what are internationally recognized principles. And Singapore is, of course, and has become one of the main international arbitration hubs because there has been a very open and pro-arbitration policy in Singapore. Hong Kong has also a very advanced judicial practice in support of arbitration. I think Australia has also a very good judiciary and case law which is pretty much in favour of arbitration.
And on that score, Caroline...
If I could just jump in there.
Yeah, please.
If I could just jump in there, Carson, to say that in Australia we have an extremely supportive judiciary, and arbitration, of course, depends on, as Alexis said, arbitration depends on the cooperation of the judiciary for the whole process to work. And here in Australia we have an amazingly supportive judiciary from the High Court through all jurisdictions. And even if I can say, you know, for CIARB itself, judges regularly participate in our courses, be it on the weekend or outside of hours. We have because they also want to join us in educating Australians about the benefits of international arbitration.
Caroline, if we are, though, to really make this a go-to destination, if there is that competition so close to home, is it going to require, though, an all-of-government effort? And I know you've been, with Austrade, working to move this up a gear, but realistically, are you wanting to see more on that score to really actively go out beyond Australia and sell this destination?
Yes, well, I think that one of the reasons why Australia has not gone ahead as far as our Asian neighbours in Hong Kong and Singapore is because of lack of visibility. Lack of visibility outside of Australia and insufficient government support inside Australia. So I think eventually we will get the message out there because we have a highly educated judiciary, of course. We have amongst the best lawyers in the world, but it's just a matter of visibility, getting our name out there, what Australia has to offer, that is really going to take us to the next level.